Good afternoon, and thank you to everyone who's joining us for our final Creative Workplaces webinar in 2024. The topic is fixed-term employment contracts in the art and culture sector. My name is Michel Hryce. I'm a Creative Workplaces Council member. I also work with Michael Cassel Group as the Director of People and Culture. I'd like to commence the webinar by acknowledging the Eora peoples of the Gadigal Nation on the traditional custodians of the land of which I'm located. I pay my respects to elders past and present and extend my respect to all Aboriginal and Torres Strait Islander people with us today. Stories have been told on these lands for over 60,000 years, and it's a privilege to gather and continue this rich tradition of storytelling. Thank you to our Auslan interpreters and the Creative Workplaces team that has put this webinar together today. Last month, if you were tuning into our webinar, we had my colleague, Council member Tina Lavranas, and talking with John McCreekers at Safe Work South Australia, and they were talking on psychosocial safety, which is such a big topic and something we're all learning about at the moment. You can access that webinar and our other webinars on our webpage. And some of you, and just to reiterate, the other ones that we've got on the webpage are Respect at Work, Working for Yourself, and one on Wellbeing and Support Act. Creative Workplaces was established for artists, art workers, organisations, and we're here to promote fair, safe and respectful workplaces for everyone involved in the arts and culture. We're also here to assist you understand what your rights are as people working in these areas and what your responsibilities are. We offer information, resources and referral information on all things pay, safety and wellbeing. In today's webinar, we're exploring the changes to legislation regarding fixed-term contracts. And in our sector, I'd like to explain to Anna and Rachel that these are common ways of contracting people in the arts and the culture sector. Recent law changes mean that there'll be some restrictions on the way we can contract people or how much we can use or not use fixed-term contracts. As an employment lawyer, I am very pleased to be chairing this session and thrilled to introduce you to our expert speakers. Anna Booth is our Fair Work Ombudsman. She's got extensive and diverse experience in industrial relations spanning 45 years. She is held in the highest regard across the political divide by business and by unions. Anna was the first female to be elected to the Footwear Clothing Trades Union. She has worked in business, in private enterprise, in public enterprise. Most recently, before her appointment as Ombudsman, Anna was the Deputy President of Fair Work Commission. Rachel Volzke is Chief Counsel, Group Manager, Legal and Policy at the Fair Work Ombudsman. Rachel has 25 years experience in the Australian public sector, and she previously worked as Senior Executive Lawyer and Assistant Secretary to the Workplace Relations Portfolio of the Department of Employment and Workplace Relations. Prior to this, Rachel worked in private practice at a top-tier law firm, Minter Ellison. Our third speaker is Daniel Roberts. Daniel is the Director of Artistic Operations at Bangarra Theatre. I'm going to talk more about Daniel later as we enter into a discussion about how what effect these changes to the law has had on Bangarra. So today I'm going to invite Anna and Rachel to give us the answers on how to understand the changes to the legislation and what must all of us do to be compliant. I say that in the context that these changes are not only in the arts and culture sector, but they're in all forms of business in Australia, all organisations in Australia, whatever their business is. For those of you who have tuned in to the webinar, please, there's a chat room. Please place your questions in the chat room. We'll get to as many of those as we can towards the end of the webinar. So Anna and Rachel, take it that it's given with this subject, we are all as clear as mud. And we are so in need of your knowledge and expertise. I'm thrilled to introduce you. Thank you.
Thank you so much, Michelle. What a delightful introduction. And Rachel Volzke and I are just thrilled to be with you. We are very appreciative of the role of Creative Australia, the existence of such a repository of knowledge for one particular sector that, of course, is so important to all of us. The quality of our lives is immeasurably enhanced by the work that you do. It touches each and every one of us. And it is quite unusual for a sector to create a repository of knowledge the way that you have. So we hope to contribute to that repository, but you will be the judge of that as we go through what we'd like to speak with you about today. And we will keep to the topic of fixed term contracts, but we're also open later on to take questions about other changes to the law, because as you know, it has been a very busy time in Parliament. I believe that today Parliament breaks up and there'll be some very tired senators and members of Parliament, I would think, wending their way home to various parts of Australia. And over the last really only, I'd say 12 to 18 months, there have been three huge tranches of legislative change through three pieces of legislation. The Secure Jobs Better Pay legislation, which is where the fixed term contracts come from, and then the Closing the Loopholes 1 and 2. And there's a lot of consistency, I think, in the purpose of that legislative change, but of course it lands differently for different sectors, and yours is a unique one. I might also say that I'm the proud mother of a visual artist. I say visual artist because I once introduced him to a friend as a photographer, and he took me aside later and said, "Mum, I'm a visual artist." So he's a creative photographer. So everybody on the webinar will know that that means he is penniless and that he is very insecurely not even employed but engaged. And so this I have a lot of personal stake in your ability in Creative Australia to support your arts and culture community. So with that introduction, Rachel and I are going to share a set of slides, and we will try to explain the origin and the purpose and then the application of the fixed term contracts legislative changes. And then when we get to questions and answers, if there's some specifics, I will definitely rely on Rachel as our legal expert. Rachel is, as Michelle outlined, the Chief Counsel of the Fair Work Ombudsman and is also the group manager of our legal and policy group that has within it nearly around 200 people, all many of whom are fantastic lawyers. So she's well supported and I'm well supported by her as well. So I wonder, Patrick, if you might just pop that first slide up with a little bit of information on it, and I will speak to it. I did want to give some context for our role as the Fair Work Ombudsman, and of course it makes sense as to why we're here today, and then say a little bit about what I understand to be the, if you like, the harm that was sought to be addressed by the changes, because sometimes when we don't understand the origin of things, when they are tricky and difficult for us, we can get a bit grumpy. and I don't blame you. The Fair Work Ombudsman's role therefore is to kind of mediate between or be an intermediary for you between all the change that happens and continues to happen, as Rachel, I beg your pardon, will tell us later about some of the more recent changes. So law doesn't just change and then stay stable. It actually keeps continuously changing, and that's why our education and advice role that I've identified there on the screen is so critical to promoting harmonious, productive and cooperative workplace relations, which is our core purpose set out in the Fair Work Act. We are a creature of the Fair Work Act, just like the Fair Work Commission is a creature of the Fair Work Act. We do quite different things. So our role includes providing education and advice, but it also includes more active involvement with businesses and workers and their representatives, such as employer organisations or trade unions, to resolve workplace issues. So when people come to us with concerns, if the advice we give doesn't resolve it for them, then we can use our dispute assistance people with their dispute resolution capability to try to resolve the matter for that person or people. And then if indeed that's not successful, as the slide suggests, our role is also to monitor and investigate compliance. So an individual coming to us with a concern that's not resolved either by information and advice, not resolved by dispute resolution, might go forward to be investigated. But also we have a role to be at large in the 1,000 employing businesses in Australia and on behalf of the 14.5 million workers to take action where appropriate to enforce the Fair Work Act. And of course, the Fair Work Commission, in contrast, its role is to create the new laws, and it does that not only by the national minimum wage and creating the awards that we're covered by, and there's two of relevance, I believe, in your sector, the Life Performance Award and the Amusement Award, and their coverage is different, and that's no doubt something that we can talk about later, but also to approve enterprise agreements. And many of the employers or businesses in the creative arts and culture sector will have enterprise agreements, and of course there's the statute that sits underneath all of that, the National Employment Standards. So our job really is to provide an explanation of that so that those who have obligations, employers, can understand what their obligations are, and those who have rights, workers, who are best able to have those rights met if they understand what they are. So the fixed term contract provisions, without sort of labouring the point and going over the explanatory memorandum that accompanied the bill, but my understanding as a practitioner in the field, and at the time of this legislation, I was between the Fair Work Commission and the Fair Work Ombudsman. But prior to leaving the Fair Work Commission or being kicked out at the grand old age of 65, because that's what happens in the Fair Work Commission, I did a lot of work in sectors like universities, where fixed term contracts were often used to avoid obligations and to have the impact, I suppose, or the effect of workers' rights not being upheld. And so that harm, if you like, of insecurity or precarity, where people who were in work, which on the face of it was ongoing work, but was subject to fixed-term contracts, I think was at the heart of the changes, which many other parts of the legislative change in closing the loopholes, like the same job, same pay provisions and the employee-like regulated worker orders, which are now able to be issued by the Fair Work Commission. They're all looking to really I guess, support the same kind of direction in Australia, which is to give workers who were otherwise insecure and precarious more security and certainty in their lives. And so recent changes to fixed-term employment contracts had that purpose. But of course, when you make a general legal change that is intended to cover the entirety of the workplace community, you can find that there are particular circumstances where those changes don't quite fit. But we thought we would deal with the general first and then go to the particular to assist you in understanding that. And I have a fairly simple, I like to break things down because I have a simple mind. So I think if everyone who's watching this webinar can remember just two things about the changes to the fixed term contracts and then deal with all of the exceptions after that, it can be helpful. And the two things that strike me as worth remembering are that the effect of the legislation is that you cannot have more than 2 years as a fixed term employee in a particular enterprise with a particular work that is covered, by that first contract, and if that first contract is less than 2 years, you still can't have it renewed more than once, even if that renewal ended up being less than 2 years. So you've just got to remember the 2 years and the no more than once, and that's kind of the generality. But as the slide suggests, and I'm sure this is self-evident to you because you live every day with these contracts, but it is a contract that terminates at the end of a set period. And of course, it's essentially a contract, and this is part of the reason I think for the changes as well, is that it doesn't attract the unfair dismissal provisions of the Act. So if you're in a fixed term contract, you're by definition not covered by the ability, you have no rights to seek an unfair dismissal remedy, and also there's no redundancy pay at the end of the employment. And those two things were things that I think that some of the motivation for bringing those rights into the view of a range of employees who otherwise might be doing work, just people were being renewed over and over again on fixed term contracts, and that happened in universities quite a bit. But there's basically sort of three parts to what are called limitations. So this is a word that you might also say are just rules, but they are termed as limitations. And as I've already said, can't be for longer than 2 years, including extensions and renewals, but can't have that option to extend or renew more than once. And the third limitation is quite a complicated one. And for that reason, I'll begin to hand over in a moment to Rachel. See, when it gets complicated, hand over to your Chief Counsel. But I want to just point out to you that we have what's called a fixed term contract information statement, and that's pictured there on that slide. And it sets this out pretty well, actually. I think it's one of the best ways of understanding it. The fixed term contract information statement does deal with the time limitations that I've just dealt with. It does deal with the renewal limitations, and then the third set of limitations, which is called consecutive contract limitations. A little bit more complicated, but it's nicely set out in this statement in 2 columns. So I'm just going to mention that what you have to have to be offered a new fixed term contract, or that you actually can't, beg your pardon, I'm going to rephrase that, what you employees cannot be offered a new fixed term contract if features, as I am just about to identify, exist, and one or more of another set of features exists. So the statement sets out in column A the features that all points apply, is how it's put. The previous contract was also for a fixed term. The previous contract and the new contract are for mainly the same work. So you can see why that's there if you remember the sort of original motivation for these new laws. And there is substantial continuity in the employment relationship. between the previous and the new contracts. So if you hold those things in your mind and then you add one of any of the following, then you're in a situation where that the employee cannot be offered a new contract. And those items are that the previous contract had an option to extend that has already been used, so kind of expired. The total period of employment for both the previous and the new fixed term contract is more than 2 years. So once again, there's that 2-year limitation. The new fixed term contract contains an option to renew or extend. And there was an initial contract in place before the previous contract that was for a fixed term, that was for the same or similar work, and where there was substantial continuity in the employment relationship. Now, I don't expect you to remember all that, but I wanted to point out that it's in that statement. It's really nicely set out. And so when you're grappling with this after this this webinar, you know, what did they say again? That document which is required to be given to anyone who has the fixed term contract when they start employment, then I think it is actually much easier to understand perhaps than it might appear at first blush. So the last thing I would like to say before I hand over to Rachel is that, and I think this is hard conceptually because I've talked about limitations, and now we're going to talk about exceptions to limitations, which is a bit like a double negative and really hard to conceptualize. But there are exceptions to the changes, and they are around the high income threshold, which is $175,000 at the moment. So there is, if you like, a carve-out, we can call it that. There are some positions that are subject to government funding and contrary to award provisions, which absolutely affects you. And Rachel will talk about that in a moment, and means that whilst there's these blanket limitations on the use of fixed-term contracts, and remember the 2 years and no more than once, there are also exceptions to those limitations, and it's my understanding that I'm sure good advocacy from your sector has resulted in some of those exceptions, and there's some recent changes to the Live Performance Award which pertain particularly to, goes without saying, live performances, that will assist you. And we have worked closely with your Kate Schaffner, who has also most recently been at the Fair Work Commission, and I worked closely with Kate back in the day when I was in the Commission, and she's a great acquisition for you with creative workplaces. And we have our own technical experts in the Fair Work Ombudsman. Gabrielle Lewis and Larry Hamilton in particular have been working closely with Kate, and will be happy to continue to do so to really tease out some of these points that might, when you have a particular circumstance that you want to understand, need to be tailored and crafted, to the circumstance that is being presented to them. So you're in good hands, and you'll be in good hands with Rachel now as well, who is going to take over from me and go into more detail.
Thank you, Anna, and it's lovely to be here today talking to you about absolutely what is a very, or can appear at first blush to be quite a complex area. I think probably what's important in this context to talk about as well is the journey that there has been for the changes in relation to fixed term contract reforms. As Anna said, they were part of the Secure Jobs Better Pay, and essentially those new rules that Anna's talked about took effect from the 6th of December last year. And it's important to note that at that time there was essentially a carve-out, for the live performance industry award at that time, so that essentially the new rules and limitations that applied to fixed-term contracts would have no application in that sector. And then I guess to make it a little bit more confusing is that there have been subsequent changes that have been made by way of regulation. So, delegated legislation that sits underneath the Fair Work Act that took effect from the 1st of November 2024, so the 1st of this month. And essentially what they did was, in terms of this industry, they turned off that broad exception. And the reason for that is because, as Anna pointed out, one of the rules that applies, that essentially enlivens that double negative, where you will have a displacement of these general rules, will be where there is a contrary award provision. And it's essentially, that which has occurred earlier this year, that has provided for, certainly in relation to the live performance awards, some, I won't say contrary, but some more specific rules around how fixed term contracts will apply in that circumstance. Before we get to that, though, I think it's probably good to have a look at a real life example of how these more general rules around fixed term contracts will apply. So if we could have a turn to the next slide, please, for the case study. Thanks, Patrick. There we are. Yep. So, and this is probably the most difficult, part, I guess, of those limitations to apply. But essentially, there's an example of Ahmed being employed on a fixed term contract as a site engineer for a construction company. His initial contract was for the period of 1 January 2022 to 31 December 2022. It included an option for a 1-year extension, which his employer used, making the new end date 31 December 2023. On the 1st of January of this year, Ahmed signed a new fixed term contract for a term of 1 more year for the same position. And essentially, and I think as it's made clear on the slide, that would be contrary to the new provisions, for a number of reasons. But essentially, the previous contract, had a right to extend in it, and the total employment period under both of those contracts was more than 2 years, and also the contracts were for the same position, and there was essentially continuity in the employment relationship between the two contracts. And in terms of what the consequences of that are, and again, I'd refer you to our fixed term contract information statement, because it does sort of set it out quite thematically what occurs. But what it means is that rather than the contract coming to an end at that finite period when it otherwise would under a fixed term arrangement, that will not occur. So that's an example, I guess, of what the general position is. And if we can turn to the next slide, please. So as I spoke about briefly, there are additional exceptions to those limitations that apply. And I've made reference already to the extensions and changes to those exceptions, which took effect from the 1st of November 2024. And certainly for the arts and culture sector, my apologies, sorry, I'll just, someone else was trying to ring me. Broadly for the arts and culture sector, those that might be most relevant is where there are specific award exceptions to the use of fixed term employment contracts, particularly for some weekly performers through variations to that award. And also there's an exception for certain employment contracts where they're entered into by employers who are essentially charities or not-for-profits. Again, particularly for that second exception as well, that is set out quite clearly in the information statement, and there are some, sorry, oh my goodness, it's gone. that need to be satisfied in order for it to apply. So I'll just sort of park that one for a moment and talk about those where there are contrary award provisions. And for that live performance award, as I set out at the beginning, the beginning position when the Secure Jobs Better Pay changes around fixed term employment first took effect, the whole live performance industry was carved out as an exception to the new rules via the regulations that are made underneath the Fair Work Act. And then what has occurred earlier this year is the Fair Work Commission, which is essentially, another body, but another Fair Work body, but the body that is essentially responsible for making and varying modern awards. That live performance industry award was varied by the Fair Work Commission to include specific exceptions to the limitations that have been placed on fixed term employment contracts in particular circumstances. Now, those changes took effect from the 16th of July of this year. And essentially, they include the addition of terms to the award which permit, I think, from memory, certain performers, company dancers and musicians to be employed under fixed-term arrangements in particular circumstances. Now, I won't go through all of those requirements that are set out in the award, but it is important, I think, for anyone who is covered by that award to look at the award and the particular provisions that apply to those various classifications, and look at what the requirements are around fixed term employment, because if they apply, then essentially you're taken outside those general rule limitations that we've spoken about. Just as a bit of an aside as well, obviously, there are, obviously not only awards that underpin people's employment, but, enterprise agreements are obviously a common workplace instrument as well. And it's also really important to not only look at, what might be in the award that applies to the particular person's employment, but also to have a look if there's anything more specific around this in an enterprise agreement that might apply as well. And the Fair Work Ombudsman didn't participate in those Fair Work Commission proceedings, and I'm not sure, I wasn't aware that that Creative Workplaces, whether or not they participated in that. But I do understand as a broad proposition that really the changes that were facilitated by the Fair Work Commission was to allow for, greater and more flexible use of fixed term contracts, really to reflect the nature of live productions, particularly, for example, a live performance running for a season and being extended. And really the flexibility in the award is to, acknowledge that and make bespoke arrangements that might be more relevant in that circumstance. As I briefly pointed out as well, there's obviously also the charities and not-for-profit exception as well. Look, I don't intend on setting out in detail what the requirements are, but I think probably for the purposes of today, what's really important to sort of have in the back of your mind is that, if there is an employee that's been engaged by a registered philanthropic entity or charity and the funding for the position has been provided in whole or in part by government or other philanthropic funding, then it's probably important at that stage, with those sort of threshold requirements having been met, to actually this is something that we need to consider and look at to see whether or not one of those other exceptions might be enlivened. And then the other thing that, and Anna will talk about the resources that we've got there, but just before I hand back over to Anna, Probably a couple of other things just to mention in this space is that there are anti-avoidance provisions that apply as well, essentially to ensure that employers aren't taking actions to essentially try and get around these new fixed term rules. It's really important, whether it's through, an organisation, an employer org, through our info line, etc. If people have queries, to make sure that they ask questions about what the position is and be clear on what the rules are. And certainly our info line is a good first point of call for that. And for those of you who might know a little bit about the Fair Work Act already, obviously we've got these provisions called the general protections, which essentially protect employees and workers' workplace rights and how they might be exercised. And obviously the protections around fixed-term employment also essentially become one of those protected attributes and can be enlivened in the unfortunate circumstance that there might be adverse action, dismissal, some sort of other prejudicial action taken against the employee. The other thing that I'll briefly mention is just dealing with disputes. So, as is always the case, and as we encourage at the Fair Work Ombudsman, if an issue arises in the workplace, the first point of call is always to try and resolve it, within the workplace and hopefully be able to achieve that resolution. But certainly, if that's not possible, we've got on our website, we've got information around, how to raise your problem in the workplace and how that might be escalated. And certainly, if it can't be resolved, then the next step would be to go to the Fair Work Commission to have them deal with that dispute. And usually that starts with conciliation, mediation, and may well progress to arbitration, which is essentially where the Commission makes a binding determination around the dispute, but that must occur with the consent of both parties. Look, the only other thing that I'll briefly mention, and it doesn't go quite to fixed term, but just sort of more broadly in this space that might be of interest as well. I also understand that there are Fair Work Commission proceedings that are on foot at the moment, both in relation to the Live Performance Award. I understand, though, that that's more a technical review of, wording and definitional concepts within that award. But there's also, I think, the Amusements Award is also within scope for the Fair Work Commission to be looking at the moment. And in particular, I think one of the questions that the Fair Work Commission is looking at is whether or not arts workers, fall within the scope of the award. Certainly from our perspective at the Fair Work Ombudsman, we are keeping a close eye on those proceedings and how they might be concluded so that we're able to roll out, any further, targeted educational materials that can assist in, employees and workers being able to determine, for example, what their coverage of a particular modern award might be. That's probably enough from me, so I might just hand back over to Anna.
And I will just conclude because I'm sure, like everybody, I'm really keen to hear from Daniel. But I just wanted to make the point that it is worth your time spending a little bit of search time on our website, and you will actually find quite a lot of resources that will assist. And if you're an employer and you don't find what you need, you can ring our employer. You can ring our 1394 as our general call line. Anyone can ring that. But if you are a small business employer, which many creative industries are, then you can get a specific advisor to give you written advice about your particular situation. So I urge you to do that. We are here to provide that education and advice, as I said at the outset. So, Michelle, with that, we'll pass back to you.
Thank you, Anna, and thank you, Rachel. That was fantastic. So much very useful information, and importantly, will give us the confidence to know where to go to add to that information and refresh ourselves. So our final panelist today, as I briefly said before, is Daniel Roberts. Daniel is currently the Director of Artistic Operations at Bangarra Dance Theatre. Daniel is a seasoned dancer, having graduated from the Australian Ballet School in 2008. He has performed across Australia with the Sydney Dance Company, as well as the Western Australian Ballet. Internationally, he has danced with the Singapore Dance Theatre. Daniel also embraced musical theatre, and us at Michael Cassel Group are very pleased to hear that. He embraced musical theatre with the production companies Oklahoma. And Daniel finally joined Bangarra as resident director. So Daniel, now we're all terribly clear on what these changes to the legislation are and how we need to approach it. And in terms of having a conversation with you now, really I want to understand Bangarra's journey. And in that journey, like 3 key points I think I would like you to focus on or for us to discuss. Firstly, what was Bangarra's first reaction to finding out that there were changes and there were going to be restrictions on the use of fixed-term contracts? Secondly, in case we get too engaged in conversation, I don't get the 3 questions out. Secondly, then after that first reaction, what has Bangarra done? What action has been taken by Bangarra? And thirdly, here now we're a year into this legislation, and certainly we had forewarning before the legislation was enacted. Where do you see Bangarra needs to go, or what you need to think about into the future? So welcome to our conversation, Daniel.
Thanks, Michelle. Thanks, everyone. Yeah, just a slight correction. I wasn't resident director, I was rehearsal director. And that role for anyone who's interested, is a role that works really closely with the dancers and also underneath the direction of the artistic director or the choreographer. So I'm someone who was very much a go-between between the creatives and the dancers, and kind of facilitate a lot of the production in all aspects. And then from there, became Director of Artistic Operations. In terms of Bangarra adopting the permanent contracts, from my understanding, and obviously it was an executive decision that I wasn't a part of, but we were informed of, is that they were really happy to embrace this move. And really from the standing point that it aligns totally with our mission in providing employment for First Nations artists, and that aligned perfectly. So we were more than happy to adopt it.
So would you say, Daniel, that the introduction of this legislation and the fact that there were now restrictions on fixed-term contracts happened at a time when Bangarra really were, similarly to the government, wanting to see how they could offer more secure employment to the dancers and the people of the company?
Absolutely. And it kind of coincided in a weird coincidence that we were starting conversations in how to better performance manage the dancers. And I guess that aligned with those initial ideas that we were exploring, but maybe pushed us harder to try and figure it out.
Great. If we look at the dancers then, prior to your current arrangements, were the dancers predominantly on fixed-term contracts at Bangarra?
All of them. And yes, and it's always been my experience as a dancer myself that we all were. And so I remember when I found out that these guys would eventually be given permanent contracts, I was like, wow, that would feel great as an artist, because I really recognize every year, coming from a dancer and then being someone who manages dancers, I really recognize that anxiety at the end of each year when you're going into the who is it? The artistic director's office. Because you've gone through this year, you might have 10 years of experience, but at the end of that year, you need to be able to prove yourself again. And there is a theme of lack of feedback, I think, between artistic leadership at times and dancers. And this change forces artistic leadership to speak to the dancers throughout the year. And sorry, I am only speaking from a dance perspective, because giving them a chance to get better if things are wrong or if things aren't working out, rather than, well, the contract's up at the end of the year, so we'll just move on.
So that in itself is a wonderful reform for the way that we treat our employees, isn't it? Really, it's sort of saying it's our responsibility as managers to manage properly, and if we have concerns about people's employment, we should be talking to them about it, and we should be giving them opportunities to try and do something about any issues that management see arising.
And perhaps it's now finding the language, and that's what we're working towards and trying to work through at Bangarra at the moment, is finding the language that interprets the artistic vision and the artistic director's vision, and how that dancer either is or isn't meeting that, and how we can help that dancer meet that vision. So and sometimes in the arts, I think a lot of it can be vibe, so then how do we put it down on paper, and how do we make both parties understand that both need to meet in the middle somewhere?
Yeah, I mean, that's a fascinating thought. I think one that if you can achieve it and enlighten other companies, everyone is going to be thrilled. It's always much easier if you're performance managing someone in a context of it being sort of a behavioral issue or an issue with not being terribly great at what they're doing in a part of their job. So it's often very easy to identify where the problem stems from, and often easy to identify some ideas to change and improve that situation. I think people in the arts often get very challenged when you get to that more creative, artistic interpretation and valuing of that, and what the artistic director is looking for, and why perhaps someone isn't delivering. I mean, often, when we're in that performance space, you'll have the creative team offering notes and having discussions with people. So that is done regularly. But that broader vision and what they want in the next season, linking into these dancers, is going to be quite remarkable, I think.
What we tried this year was, so it was great to go and speak to the dancers this year. It was the end of last year that we let them know that some of them would be moving on to permanent contracts. Those that had been here for 2 years or longer would be moving into permanent contracts for 2024, and explaining to them the process of, so we're going to have these sessions throughout the year where we meet and we work through your goals, and we'll provide feedback and we'll remind you of the goals that you set. I think they were kind of like, wow, because it's always been a bit, ad hoc. Maybe that's my own bad management. I don't know, but I think it was really relieving. I imagine it was relieving for them to know that, I have these meetings set, and they're keeping track of my progress. And I think sometimes with dancers in particular, we rely on the individual to track themselves, because it is you do approach things so individually, or approach practice individually, I should say. I'm not sure we got it right this year with the form that I created. So I'm working with our HR manager to try and interpret what the admin team use for their performance management plans. And it's not performance management plan, it's more like what your plan is for the year.
Yeah.
Yeah.
What HR would probably call key performance indicators in an office environment.
Yeah.
Yeah.
So it's tricky. It's tricky to interpret that language and make it relevant to an artist. But we're doing our best. And we've just decided, like, look, this is a fluid thing. It's legislated. Let's work with it and let's figure out how we can do it best.
So sort of, look, I think like all changes, and given the fact that Bangarra's journey is just simpatico with the change of legislation and both things, yeah, so the company and the government had the will at the same time to offer more secure employment to people working with you. I think first steps of all trying to put these reforms into practice, none of them are perfect at any given time, particularly when you're trying to define something that's very new and different for the dancers with the artistic aspect to it. But in terms of KPIs and systems, most companies, I would say, do have good intentions in this area and try and set up. And then often people just get so busy with everything else. It would sort of goes a bit wonky, or it just gets lost for a while, or it delayed. And I think these things are always work in progress. So it would seem like part of my question for you, for Bangarra, for the future, for what you're focused on for the future, is really trying to get that right, like to get that assessments system, both in practice and articulating it right for the future. And I would expect with a willingness to continue reforming it where you need to.
Yeah, that's exactly right. It's definitely at the moment for us constantly in review. There's a lot of people that interact with the dancers as well. It's not just me and the artistic staff. They also have a whole clinical team that manage them. And then they have their own goals and their own professional development as well. So we need to capture all that. And we're still trying to figure it out. But I think hopefully it opens up more dialogue between artists and the artistic employers, and the relationship, deepens, and then the goals become better understood.
It sounds like it will. What was the first reaction of the dancers to the fact that you were going to start offering some ongoing employment contracts?
Look, I mean, I've worked at Bangarra now for 7 years, and it's a beautiful group of people, but they are a tough crowd. So I didn't get much. I didn't get a huge
You didn't get an award?
But in my mind, they were happy to hear it.
Yeah.
But I think it was more probably a sense, probably like not expected. I don't think that I think it would have been really unexpected for them. And it took them a while to get their heads around, me starting at the start of the year going, so what are your goals? What are we going to work on this year? Like and then recording it, like it was quite official, and we hadn't had that interaction before either. So it's definitely been a shift.
Yeah. So it's just sort of getting confident with each other. And like this is a significant change. So you're probably going to have to, for it to become more effective, it will need over a year. It will need a couple of years to work your way through this as you go through the processes and tweak them and improve them.
I think what was great, and I don't think they would mind me sharing this, is that when we would normally hold interviews for the next year, whether or not the dancer would be coming back, I felt a sense that they came in with different issues to talk about, rather than being worried that the main point of the interview was, will I be coming back next year?
Yeah.
So
Yeah. That anxiety that goes with the insecurity and not knowing and the confidence.
Exactly. And so then I think what happened was, what I think is happening now is issues that are important to them being able to be brought up without the fear of any kind of reprimand. That's
great, isn't it?
Mm-hmm.
Well, Daniel, we're getting close to time. We better save some time for some chat room questions. But it was so wonderful to hear that journey so far, the short journey. But it sounds like you've achieved an enormous amount in that time, and it was wonderful that both legislative change, government will, and the will of Bangarra simultaneously connected together.
Totally.
Yeah. Okay, now we've got plenty of questions in the chat. So I'm going to ask, all our panelists are here, and I am just going to see if we can allocate some questions. One for Rachel or Anna. Scott has asked us, where a fixed term contract has been used on a project, what happens to the end date in the fixed term contract if the project finishes early? Does the fixed term contract just end at that point?
We're going to ask Rachel that question.
Yes.
I'd ask Rachel that too.
I'm here. I'm not sure. I can't start my video, so my apologies if you can't see me. But essentially, look, with that, the answer will be it will depends. And the first thing that you'll do is have to have a look at the contractual terms, and which often will provide for early termination, etc. And that will be your starting point to determine what the outcome is.
Right. Thanks, Rachel. We're also getting some questions in relation to other states and people, one in particular from Western Australia, because we must always have to remind ourselves that industrial relations in this country is complex, and we also have state systems that will cover some people. Often those state systems can be quite similar to Fair Work Act, but often they're different. And they're often our people that are employed by the public sector in each state will be under different arrangements. So Anna and Rachel, have we got any idea what's going to happen with these states in terms of are they going to come on board and adopt the federal treatment of fixed term contracts, or is there any word, or are they just ignoring everything?
Rachel, you might take a 30 seconds to explain to people what a national system employer is. And then if you do have insight into the political thinking of Roger Cook, perhaps you can convey that as well, but I suspect you don't.
No, look, absolutely. And I saw one of the first questions there was, just seeking confirmation that these provisions don't apply to what we call non-national system employees and employers, which are those outside the National Fair Work Act system. And the answer to that is they do not apply. And look, the best way that I can really describe the coverage of the Fair Work Act is, for the most part, outside of the territories. Whether or not you're covered by the Fair Work Act will depend on whether or not you're employed by a business that is a constitutional corporation. But I definitely will have a plug for our website, because it's got a really great pictorial representation of how coverage applies. And essentially, for those sorts of employees that we talk about, so the public sector employees in the state systems, they are obviously generally, for most purposes outside the Fair Work Act. And look, in terms of what that means going forward, it's always difficult to know. Certainly, we know elements of the Fair Work Act are rolled out in other states. At this stage, I certainly don't have any, sort of intelligence or insight about what might happen, more broadly. But I mean, it is really, encouraging, particularly to have heard from Daniel around, how welcome these changes have been.
Oh, thanks so much, Rachel. Yes, it's complex always, and the complexity is worsened because of the various, systems that we work under. We've got a really good question from Joshua, and this one is in relation to exceptions for government-funded positions. One of the most confusing elements that we do not have clarity on in the sector is the exception for government-funded positions. Some are operating under the belief that if their organisation and its core staffing is funded, for example, for multi-year funding from federal and or state government, they then fall under the exception. However, I believe the spirit of this is for when the roles themselves are specifically funded and where the funding is unlikely to continue past the end date. Therefore, the exception would not apply to these organisations. Can you give some more clarity on that one?
And look, I think the length of that question tells us it's obviously quite detailed and something that I think, has to be determined on a case-by-case basis. What I would say is I'm very happy, as we've spoken about earlier, to have more technical questions directed through to our specialist advice branch or through me in the first instance to see what further clarity that we can provide. But we do know, including, I know there's questions, where there is fixed government funding or where it's not known and what that all means. And so it's really something that probably, requires a little bit more of a technical response outside of today, I think.
Thank you. I'm just going to ask one more question because I've been a very bad chair and realised that we're over time already. But it does follow that one, and it's just another one to get Anna and Rachel thinking about too. Many arts organisations exist on year-to-year funding, which can be withdrawn at any time. Should most employees be on fixed-term contracts or permanent ones?
I think Rachel's going to say it depends on the circumstances.
Yes.
And I think, but it is important, and Rachel will correct me if I'm wrong here. Remember, if you employ someone, as Bangarra are doing, on a permanent basis, and something happens so that the role that that person is doing is no longer required to be done, then there's not an inhibition to termination. Not that I wish to encourage people losing their jobs, but it's just from the business point of view, the existence of a permanent role isn't. In fact, the language, of course, we use in industrial relations is contingent upon a deeper understanding, because in the normal language, people think permanent's permanent, but it's not. And so, and also, where there's small businesses, redundancy payments, are not required. So it's not as though the arts organisation that is in that uncertain period or uncertain situation is inhibited from employing someone on a permanent basis and then being able to adjust their workforce levels to suit their capacity.
Yeah. Well, unfortunately, I'm going to have to wind it up there because we're over time. Anna, Rachel and Daniel, thank you so much for joining us today and giving so much thought and insight and giving some more information so we can start getting our head around this, or indeed pick up, give thought and sort of know where we can get further information. So thank you very, very much. Thank you everyone for attending the webinar. The recording will be up in about a week and a half. Thank you, Creative workplace team for supporting us and doing all the hard work today. And when you do leave the webinar, can you please fill out the survey for us? And there'll be lots of things to look forward to and initiatives from creative workplaces next year. Thank you so much.
Thank you. Bye.
Bye-bye, everybody.
Thank you.